One.
Hi there. I'm Dr. Tamara Relis, Senior Attorney and Director of the legal team here at RelisLaw Visa Immigration. Thanks so much for joining today. I think it's going to be worthwhile for you. The subject today is for all attorneys across different disciplines, and it's about how undocumented or clients with non-immigrant visa status can impact your case's damages, your settlement leverage, and trial strategy. So today we're going to explore how immigration status can affect your own client cases in ways that many attorneys overlook. And this also points to the reason why you should seriously consider collaboration between your practice areas and immigration, and this is more important than ever given the current climate. So whether that you handle custody, immigration, or criminal defense matters, or others, immigration status can dramatically change your client's risk exposure, the leverage that you have, and also your legal strategy within the case. So I'm going to focus now on the core issues and why immigration status, whether it's your client being on a non-immigrant visa status or no status, can affect you and your clients. Firstly, you should know that clients with undocumented or non-immigrant statuses face unique vulnerabilities in litigation. That also affects your pretrial negotiations. Courts, opposing counsel, and other government and other agencies may handle these cases differently, and that's something you need to be prepared for. So what are some of the considerations that, as an attorney, you should be thinking about? One is disclosure of client's immigration status versus protection of it. Second, for PI cases, impact on the damages you may claim or you may seek, for example, relating to future earnings claims. Another area is the effects on settlement negotiations and, very importantly, trial attendance at all, because that is an area now where ICE agents are attending, as you may know. There are immigration enforcement risks during proceedings themselves, and I'm going to talk about that a bit later on in this LinkedIn Live. So those are some examples. So what to do? When to bring in an immigration attorney, when to consult. The key is early consultation. Ideally, you want to consult with immigration counsel on intake of any client, or as soon, if you don't know then, as soon as any immigration status surfaces. What are the strategic areas you would be looking to collaborate with an immigration attorney when you have a client who is either out of status, never had status, or is in a non-immigrant visa status? So that can be any kind of visa that cannot lead to a green card, to permanent residence. These cases can include your custody cases, family court filings, anything involving non-citizens. In addition, this can affect your settlement negotiations to do with damages that you are seeking and claiming, to do with current work, current employment, future work, and your client's future plans in relation to residency and realistic outlooks in relation to the same. Are they going to be in the US? And if not, you'd want to have a backup plan to argue for to protect your client in the most zealous way. Another area of strategy to collaborate with an immigration attorney is if you work in criminal law. This is really key, always has been, but even now more so under the Trump administration. Criminal pleas or sentencing considerations are vital when immigration comes into the picture. So in terms of clients who have criminal charges against them, who are about to be heard in court, and the like, you should know that criminal cases even if they are now or later expunged or no longer showing on a criminal record, will still be relevant, still count for immigration considerations. And this can have drastic, irreparable effects on your clients. These can even lead to court removal proceedings and deportation. So past history and current action are vital. And there are some things that can be done to alleviate, to minimize, to protect. So please do always yourself and any client facing criminal charges concur with an immigration attorney prior to entering any plea or making any agreement whatsoever. I'm going to now talk about a different area in terms of your strategy in protecting your clients who are not U.S. citizens. And this relates to strategy where clients have some status, but it's expiring sometime soon in the next year, for example, or changing their status, changing their immigration status mid-case while you're in the middle of representing them. So you should be aware that even if the USCIS, the government, has not made a decision on your client's case yet, they haven't yet adjudicated it, in some cases, proof of a filed application can offer you tactical advantages. In some cases, some of the visa types offer what is called authorized stay. And so this can be tactically strengthening for you in your strategy in protecting your client. Having a case that has been filed with proof of it can avoid triggering a variety of immigration consequences that may or may not be fixed or fixable. Having a filed case, and of course an approved case, can protect your client's legal position across multiple systems, all different areas of their life in the US. And finally, having a filed immigration case can preserve trial strategy and can affect settlement values that you're going for and or that you're going to accept. So those are sort of some key areas of strategy, and there are more, of course. But now I want to turn to some current updates within the last 3 months under recent Trump administration immigration changes. So I'm a member of AILA. It's the top American Immigration Lawyers Association in the United States. I get daily updates, and of course, I'm involved on different levels. And one thing that you need to know is that there is now heightened scrutiny on non-immigrant visa extensions and status violations. So things that were passing by and were getting approved or were not having serious consequences now are not getting approved, now are. And this can swiftly adversely affect your client's position in the middle of your case. There are many, many different examples, and it even comes down to when they're going for their citizenship. If they say, well, I have my naturalization interview coming up, even then there's higher level of scrutiny now. There's much higher level of scrutiny, particularly, for example, on one area for naturalization, which is called good moral character, more than before. So these are things that you want your client to be knowing and to be doing. Life is an evidence collection for, on the legal side, to be getting the things that they need and that they deserve legally. But if they are not aware of it, they cannot take action and they will not have it. And again, this can result in catastrophic changes that may not be repairable. Secondly, you should know that there is, in the last 3 months and generally under the Trump administration, increased information sharing between DHS and state local agencies. That is, again, heightening the risks, heightening the knowledge base of the government, and reducing your tactical strategies. So again, This is something that you want to take care of early on. The client needs to take care of it early on from the get-go, I would say, once you agree to take on their case. A third change recently under the Trump administration, it involves stricter public charge interpretations, and that can badly affect adversely family-based applicants. So you may have a client who is in love with a U.S. citizen or permanent resident, and they get married, and you think everything's going to be fine because they're going to get their green card, but there may be issues to do with their own history that you may not know about, you may not have asked about, because that's not what you do on the day-to-day. And public charge interpretations can involve beneficiaries who can maybe your clients or your adversaries' clients, who have availed themselves in the past or now, but can be also in the past, of government funds in various ways. So this can include, for example, Medicaid, Section 8 housing applications, food stamps, welfare, income supplementation. All of those things can have an adverse effect in terms of when the government decides, can this person adjust their status? Or can this person be awarded legal permanent residency, aka a green card? And they may not be able to. And so this is not something to be taken for granted. And this is certainly something to be looked into and strategized with an immigration attorney at the earliest. Fourth, in terms of Trump changes recently, there is and has been an expanded use of ICE holds and court surveillance for undocumented individuals. You may have seen things online and social media, etc. I can tell you that you should only believe one site, and that site is the government's own site for any information. It's not that user-friendly, but it is uscis.gov. That's it. I'm sure you know much of the things online may have been correct and are no longer. Immigration law changes and regulations and interpretations of regulations and precedent court cases change rapidly. So really the only site that is trustworthy is the government's own site, which may or may not have all of the information that you're seeking. There is another update that you should be aware of, which can involve any client that you have that works, which is most people. There are increased workplace ICE raids, and again, that may affect dramatically and instantly your clients or the other parties in your cases. They may be there one day and gone the next. So you really need to know about the immigration status of everybody involved in the case that you're working on. And if it's your clients, of course, to do all possible to ameliorate, rectify, address any and all issues at the earliest possible and in the most robust way, to do everything to avoid detrimental results that no one will have power to correct. And lastly, in recent 3 months, there have been accelerated removal proceedings for certain non-immigrant overstays. So that's somebody who came in on a visa and they're no longer. The visa expired, the timeline expired. It could be a business investor visa, E2. It could be a variety of visas, student visas. And so those people, if they are not current on their immigration status, and there's very particular dates on when somebody's status would end, they're in trouble. So in summary, these shifts create new legal risks for your clients and for your adversaries, potentially in civil cases, in criminal cases, and in family proceedings, whether it's pre-court, negotiations, and in-court proceedings. So I want to give you now some examples of 4 different case types that may resonate with some of your experiences or some of your future experiences. So for example, case 1, a family attorney finalizes a divorce for a client who has a dependent spouse in a marriage-based case. Well, that dependent spouse who's now divorced has lost all eligibility for adjustment of status to become a legal permanent resident green card holder and can become undocumented overnight. That's serious. That's major. That can quickly result in proceedings. What to do? Well, a better outcome is that if consulted before filing and before filing for the divorce, we could have filed, for example, if it's relevant in the under the case facts, a VAWA petition that is to do with immediate family abuse. Could be psychological abuse, controlling behavior, physical abuse, etc. That comes under the Violence Against Women Act, but it covers equally men. We've had a bunch of approved male VAWA cases, or other relief to preserve your client's status. That's key. So that's case one. Another example can be a client who entered on a fiancé visa. That's called a K-1 visa. And everything was going well until the marriage that they subsequently underwent broke down. And for example, custody proceedings may have begun. Well, the family attorney didn't realize that the K-1 fiancé visa of their client cannot work to then allow that client to adjust their status, right? Adjust to become a legal permanent resident in the United States. By anyone else other than that U.S. citizen who petitioned for them as fiancé. So if that breaks up, your client, who's the beneficiary, who is the foreign national, who came in on a fiancé visa, who may or may not have had, who had the case filed by their U.S. citizen spouse, if that breaks up, that client has now overstayed and removal proceedings in that particular case were triggered. Once you're in removal court, it's very hellish. It's very, very costly for good removal defense attorneys in court. I know because I was one for numerous years. The purpose of this LinkedIn Live is not to talk about the removal court or experiences, but I can tell you that there is overflow. There are so many cases that are overdue. There are not enough judges, and justice is not always seen in my experience and in the arguments that I have made. I can only speak for myself. So what's the better outcome? Early consultation with your client could have preserved their status through other applications before the marriage broke down, before there was any divorce. And actually, in some cases, it can be preserved even after a marriage broke down, depending on the situation. So that is really, really key in terms of getting in touch with your client, advising them, and with yourself present, or them on their own if they wish, to take advice with an immigration attorney to preserve their status in any way that they may be eligible for. And obviously you want to preserve it in a maximum number of ways to raise your chances. So an application for asylum may be relevant if timing is right and situation is right. A business investor, if people are self-employed, if people are victims of a crime, a U visa, if people were a victim of coerced labor, they stayed in a job and were treated badly. This is very brief summary, but they were treated badly and kept working basically unwillingly due to fear, or as I mentioned, or VAWA options. So any sort of areas of domestic violence. And some of these that I mentioned include also not necessarily physical violence, but controlling behavior, emotional abuse, psychological abuse, which is often the case in marriage breakdowns. So there are potentially many ways to save your client and protect their status and protect their, wonderful life in the United States with all the opportunities that they can take advantage of if you act in a timely manner for them, and if they take legal immigration advice and act on it as soon as possible. Another example, speaking to the same thing, is in a domestic violence custody matter, right? For example, there's another case, this is case 3, where the undocumented parent had been a victim of qualifying crimes, but no immigration lawyer was consulted. So same thing, a U visa, for example, because they don't, also in certain cases, they don't even need, if somebody was not legally married, but was a victim of domestic violence that, that has an evidentiary base, a U visa could be applied for, providing authorized stay and upon approval, lawful status and work authorization to strengthen your client's position in the family court and in your family negotiations. So again, in this case, case 3, a better outcome would have been to have filed a petition, whether it was asylum, U visa, T visa, VAWA, for example, that can stabilize their status and support custody arguments. And lastly, I'll give you a fourth case example, and this is for business clients. Often people come from qualifying countries and they enter, we do many of these are called E2 business investor visas or manager of E2 businesses. And this is a personal injury client, in fact, not even for a family case, but for a PI case, sustained injuries that prevented their business operating, which is the basis of their visa and their ability to work in the United States and live in the United States. So the injury prevented business operation, and therefore defense counsel argued for lower damages. Why? Because E2 status is temporary and non-immigrant. A better outcome in this type of a case for a business investor or business manager would have been potentially where immigration counsel could explore with the client, for example, EB2 national interest waiver eligibility or other permanent legal permanent resident immigration pathways to sustain damages claims in PIs and legal presence in the United States for people who have been injured. So those are some examples of reasons why you stroke your clients should always concur with experienced immigration attorneys at initial case intake and anytime later if it hasn't been done at the beginning. All these different ways that having this under wraps can strengthen your position, can be life-changing for your client in terms of the consequences of everything to do with your case, whatever the area, whether we're talking about family cases, personal injury cases, criminal cases. So thank you very much. I'm going to address now some questions. Right. So here's one. Can I protect my client's immigration status from being disclosed in court? So in many cases you can, and that of course you need to check with your court's rules in your jurisdiction. But in many cases you can, and you should definitely take proactive steps to shield your client's immigration status, particularly when it's not legally relevant to the issues in dispute. You can let your opposing counsel know early that you will contest any fishing expeditions into immigration status because it's not pertinent to the, to the matters at hand that are legally relevant in the case. And again, you should, before that, coordinate with an immigration attorney if it seems that disclosure might be forced. I see, right. I have another question. So could my personal injury client lose their claim if they're undocumented? So that's important to know, that immigration status does not erase the right to access to the courts. Courts across jurisdictions uphold the right of undocumented individuals to sue for injuries or damages. And so if your client's immigration status is revealed, though, there is the issue that they could risk removal enforcement action. So they have the right to be in court, but now it's a precarious situation and involves risk. And that risk is something that needs to be shared with clients. The risk can sometimes deter clients from pursuing valid claims. And that's obviously why confidentiality is critical. In fact, you don't need to ask a client about their immigration status up front unless you are facing a line of questioning or defense tactic that may raise it. But in terms of lawyer-client confidentiality, for the reasons that I mentioned earlier, that may be something that can be helpful to your client and to their future life. If immigration status does come up, again, you want to loop in an immigration attorney early. And I think last question I see here, how fast can an immigration attorney intervene if status is at risk? So the answer is very quickly. But again, it takes time for evidence collection. Often clients have the evidence, but it's just obtaining it and crafting it to meet the regulations. But generally, immigration attorneys can act very quickly. Again, the sooner you bring us in, the better we can mitigate risks. So if your client is undocumented with no removal orders, they may qualify for relief, like asylum, U visa, T visa, DACA, TPS, etc. We can evaluate even before filings and begin quickly to create a paper trail of good faith efforts that may prevent immigration enforcement. So don't wait till immigration status becomes an irreparable crisis in your case. If the status might come up, even indirectly, or you have a fear of it or a concern, bring in an immigration attorney early. We help you protect your case and your client from unnecessary exposure. So thank you for this. And in summary, the purpose of this LinkedIn was to foster a bridge of collaboration for other types of attorneys who may not be aware of immigration consequences for your clients, wanting to provide a more holistic protection for your client, and who have compassion for the situation, even outside their realm of expertise. They don't have to be high risk, these situations. The key is to act early and swiftly and collaborate with immigration counsel to protect clients and strengthen your legal strategy. So thank you very, very much. I hope this was helpful for you. In appreciation of your attending today, this LinkedIn Live, I want to let you and your clients know that if there is a need, we offer here at RelisLaw complimentary case evaluations where you and or your client can speak directly to one of our immigration team who collaborate with an attorney here. We ensure that there's no immigration consequence overlooked. And we are linked and collaborate for all tricky, they're often very, very tricky situations, unusual situations, all kinds of factors. So we really look very thoroughly and often concur with other immigration attorneys across the country so that we can really give a most secure response and advice in relation to the unique situation that your clients may find themselves in. Thank you so much and have a great day.